Chapter 9 is about resolving negotiation disputes and the use of economic pressure. So there are some resolution procedures that involve a neutral third party. So impasse is the point in negotiations at which the parties have hardened their bargaining positions and no voluntary settlement of the dispute is likely to happen. You can move to mediation, where there's an individual with no authority to impose a settlement, but uses persuasion and personal credibility to facilitate the bargaining process, or at least restarting the bargaining process. So when we talk about interest arbitration procedures, there are different types. There is a conventional interest arbitration, where the arbitrator considers each party's settlement terms and accepts one party's or fashions a compromise settlement. And then there's a final offer total package, where the parties present their settlement terms on all issues and the arbitrator has to choose one package to be implemented in its entirety without alteration. Final offer issue by issue considers each issue by the arbitrator rather than the whole package. So it's not a all or nothing. There are some criticisms about interest arbitration. Arbitrators tend to split the difference in making the decisions. So it can result in extreme positions for the negotiating parties. Sometimes parties can become too dependent on the arbitration, and it tends to have a narcotic effect. Some other third-party procedures are arbitration mediation, where a third party is both the arbitrator and the mediator, and there's a reversal of procedure order. The tri-offer arbitration is where both parties and a neutral third party suggest settlements. The double final offer arbitration is where each side involved submits two package proposals that are roughly the equivalent value. And then there's night baseball arbitration, where each side submits a sealed final offer and written briefs discussing the relevant issues. So let's talk about how economics can start to pressure to either side to resolve the dispute. So unions will use strikes. They're costly. They're looking for sympathy from other parties. So when they're striking, they're getting more people involved. There could be a work slowdown, so production is not as fast as it was before, which can cause economic damages to the company. And then there can be boycotts also. So with boycotts, other individuals, outside individuals, aren't going to be buying the product or using the services. So what the employer can do is a lockout of employees and use temporary replacement employees. And then they can use responses to strikes by permanently replacing workers. Let's talk about the purpose of a strike. So usually it's to resolve the union's internal problems. It can remove tensions and release frustrations. It unifies the different people that are involved in the union. And it can prepare members for a realistic bargaining outcome. When employees are striking, they have to make sure that they're not doing anything out of the realm of conduct towards managers or the property or things like that. So there are some things that would be considered serious strike misconduct. misconduct. So if there are any acts of violence that are directed towards managers or coworkers or customers even, if there is intentional destruction of private property, so if somebody is vandalizing the workplace, and also verbal threats intended to intimidate or coerce an individual to become part of the strike or to do something that's not appropriate. So it could go to court if it's a serious misconduct, and the court will consider the context in determining the severity of the acts. So were you shouting obscenities at your manager, or were you actually throwing objects? Picketing is a form of protest where people congregate outside the place of work or location where the grievance is taking place. No picketing activities can be used for violent or unlawful purposes. There are only specific times when picketing can occur, and picketers need to be careful of their noise level and the number of people walking the picket line. Any signs that are being held up and used to convey messages have to be truthful, and they have to have clear identification on the employers involved in the dispute. There could be a time where employees will picket a secondary employer who sells the products or services of the primary employer. So if they're unhappy with their own employer, they can picket a secondary employer who's selling their products. For this situation, the primary employer still has to be identified as the target of the picketing. And the picketing needs to focus only on the primary employer's products and services. So if employer B is selling the products as the secondary employer, you can't picket with the secondary employer's name on it. There's a lot of great information in the book about resolving negotiations and how strikes and picketing works. So I encourage you to read more about it in the chapter. That's it for chapter 9. We're going to move on to chapter 10. Chapter 10 is about contract administration. And there are items that go into an investigation when it comes to administration. So you have to look at the different types of evidence. So there can be testimonials, physical evidence, demonstrative evidence. You also want to look at the characteristics of an investigation. You want to look at the speed, the thoroughness, and if there's objectivity. So a grievance comes about when an employee is alleging a violation of the labor agreement that was submitted to the grievance procedure for a resolution. Employees' concerns that are unrelated to the terms of the labor agreement are not considered grievances. Grievances can be filed for any reason, and they're either accepted or denied by management based on their perceived merit. So if it doesn't have to do with the labor agreement, it's most likely going to be denied. Most employees will write a written grievance, and the reason they do that is because it helps to maintain a record to guide future actions and saves time in deciding similar grievances. It cuts down on the emotions that are involved and permits a rational discussion. It also helps management and labor to focus on the original grievance. So if you're in the midst of negotiation or in a trial or something like that, you can go back to the original grievance if other things are clouding the water. Written grievances can also discourage employees who are reluctant to sign a written protest. So, everybody might get up in arms about things, but if it's written down, they might have a change of heart. And then it reduces the overall number of grievances filed. So this is a few lists of what the potential subjects could be for grievances. So for administrative issues, is it use of seniority? Is it layoffs? Is it training? Is it safety and health? Is it discrimination? For economic issues, it could be wage rates or job classifications or overtime assignments, things like that. And then with employee discipline, it could be reasonable rules, mitigating circumstances, excessive penalties, communication of the rules, insubordination, things like that. So typically, the person who files the grievance are employees who are younger and more active in the union and less satisfied with their job or their supervisor or even the union itself. And they'll file to protest something that violates their contract or to bring attention to a problem that's happening in the workplace. Or they want to get something out of it. There can be some effects on non-union firms. So if a grievance is filed, it can trigger union organizing drives. So if something is going wrong with the employer and the labor force, it might motivate people to bring in a union. But it can also cause firms to adopt grievance procedures if they didn't have them in place before or if they needed to be updated. So the effects on a grievance in the union firms is it allows the union to address employee concerns that aren't covered in the bargaining or labor agreement. And it brings about an orderly approach to resolving organizational conflicts. And then it also encourages this upward communication. So employees have that voice and they're bringing it from the quote unquote lower levels up the ranks to the higher management levels. In preparing for a grievance procedure meeting or an arbitration hearing, there's several steps that need to come into play. So you have to gather evidence and then determine the facts and substantiate them. You want to assess the facts for credibility, accuracy, reliability, and consistency. You want to frame your arguments, seek coherence, consistency, and credibility, prepare the witness scripts, and then you want to be prepared for any challenges and defenses that may arise. So there's different approaches by grievance mediators. So there can be transformation or collaborative mediation. There can be evaluative mediation or directive and result-oriented mediation. Transformation or collaborative mediation is when the mediator tries to get the parties to discover their own separate and mutual resources and understand the other party's point of view. So they're collaborating together, they're working together to resolve these issues. Evaluative mediation is when the mediator offers no specific solution, but helps the parties understand the strengths and weaknesses of their position and begin working together. So the mediator is just evaluating the situation and evaluating the points of both parties to help them work together. For directive or results-oriented mediation, the goal of the mediator is to reach a specific solution to the problem. So the mediator will meet with both parties, allowing them to speak directly to only the mediator. The parties are allowed to caucus and engage in confidential communications with the mediator, him or herself, And the mediator meets separately with the parties to move the negotiations towards closure. So then there's not a lot of emotion involved, and there's not this back and forth. They can just get a clear understanding of, this is what I want from this side, and this is what they want from that side. So other than mediation, there are some other alternative dispute resolution forms. So there can be open door policies, which encourage employees to speak to their higher level supervisors about workplace problems and how to solve them. You can have an ombudsman or ombudsperson who is a go-between. They're an employee advocate, so they're there to help resolve personnel problems. You can have a peer review system, which is a panel of employees who hear both the employees and the company's arguments and then come up with a decision on their own to resolve that matter. And then there can be early neutral evaluation. So it's a mutually agreed upon third party who evaluates the merits of the problem and then renders a non-binding advisory opinion on the matter. Grievance resolutions should help the parties move forward and build stronger relationships. The union has a duty of fair representation. The union has a legal duty to fairly represent all union and non-union members of the bargaining unit alike. Meeting the legal duty requires that unions have to consider the interests of all members and take their positions honestly, in good faith, and without hostility or arbitrary discrimination. These are the 7 golden rules of a union's duty of fair representation. So they have to consider all grievances solely on their merit, investigate each grievance promptly and vigorously. They cannot miss time limits. They have to keep records. They have to keep the grievant informed of what's going on. There have to be valid reasons for any action, and if the grievance lacks merit, they have to drop it. So that was an overview about grievances and why they're important, how they happen, who files for the grievance. If you have any questions about chapters 9 and 10, please reach out to me. I am here to help, so just send me an email. And have a great week.